Today we are looking at the area of US constitutional law and the role of the federal Supreme Court in its development. As we have seen, there are two types of constitutional law in the United States. State constitutional law, as each of the 50 states has its own constitution, and federal constitutional law. We will be limiting our discussion today to US federal constitutional law. The history of US constitutional law begins with the Philadelphia Convention, which was organized to draft a constitution for the newly created United States. The drafters achieved this aim with elegant simplicity in 7 easy-to-understand articles. The first 3 articles establish a US federal power, creating a legislative power, an executive power, and a federal judiciary. The remaining 4 articles set out both the relationship between the 50 states and the federal powers and the rights and duties of the 50 states. The drafters of the Constitution had one specific aim, namely to create a federal government having enough power to be able to act on a national and international level, but not so much power that it would be able to dominate the 13 states. To achieve these aims, it was decided that the federal government should 1. Be based upon Montesquieu's theory of the separation of powers, so as to allow the creation of a balanced federal power and to prevent the development of a federal dictatorship, and 2. That the federal government should be a government of enumerated or restricted powers, so that it would not be able to take too much power from the individual states. However, despite the intentions of the drafters of the Constitution, the scope of federal power has grown inexorably over the last 200 years, namely as a result of the interpretation the Supreme Court has given the Constitution and its provisions. Now we are going to look at the role of the Supreme Court in defending the Constitution. A Constitution cannot be a static document and must, if it is to remain relevant, change with the times. However, amending the US Constitution is extremely complicated, and consequently, the federal Supreme Court has played a major role in its evolution. Indeed, through its use of the power of judicial review, the Supreme Court has made itself the primary guardian of the rights and duties set out in the US Constitution, and the interpretation that it has given the Constitution has led to an increase in the size of the federal government. Judicial review is an important power and not only ensures a uniform interpretation of the Constitution throughout the United States, but also represents an important control on the exercise of both federal and state power. Significantly, the power of judicial review was not expressly given to the Supreme Court, and some commentators have even referred to it as amounting to a type of coup d'etat. However, it is considered by the federal courts to be an implied power, and the question must be asked, which US institution, if not the Supreme Court, could act as referee between the state and federal powers interpreting the rulebook or constitution that governs relations between them. Moreover, the Supreme Court has put this power to good use. For example, the power of judicial review, by applying the Bill of Rights to the states, has effectively allowed the Supreme Court to guarantee all Americans access to basic human rights, no matter the state in which they live. Finally, it is interesting to look at the role of the Bill of Rights. The Bill of Rights introduced the first 10 amendments into the US Constitution, establishing many of the civil liberties Americans take for granted today. These rights include the right to free speech, religious freedom, the right to assemble and protest, the right to a lawyer, and the right to a fair and speedy trial. When adopted, the Constitution did not contain a Bill of Rights, and so it was agreed that the Bill of Rights would subsequently be adopted. This was done in 1792 and was considered by the states to be an essential safeguard to protect their citizens from the newly created federal power. As a result, the purpose of the Bill of Rights was to control the new federal government and not the states, and it was for this reason it was made not directly applicable to the states. Consequently, for a long time, the Bill of Rights only applied to the federal government. This partially explains the later divergence between northern and southern states as regards their respective racial policies, and indeed the subsequent growth of the civil rights movement in the late 1950s. However, from the mid-20th century onwards, the Supreme Court, through its power of judicial review and its theory of selective incorporation, began to apply the Bill of Rights to the states. Did the Founding Fathers envisage the Supreme Court having the power to do this? Probably not. But by getting rid of apartheid in America, the Supreme Court, with the support of politicians such as the Kennedys and Lyndon Johnson, dragged the southern states kicking and screaming into the 20th century, finally healing the ongoing century-old Civil War rift between these states. In this way, the Supreme Court has guaranteed all Americans basic civil liberties. This could perhaps be the Supreme Court's greatest achievement, and in the eyes of many justifies the court developing powers it was perhaps never actually granted. We hope you enjoyed this discussion of US constitutional law.